force. But if there was a task force, she didn't work for it. But if there was a task force and she did work for it, then it was too tenuous, for anybody to know about it. Then they respond on about the fourth one. If there's a task force, she worked for it, and Kim Worthy knew about it, Kim Worthy had nothing to do with it. And then fourth, and it's just boggling, it's like talking to, wait a minute here. The fourth one was, well, we're a big office. We have lots of separate divisions. Well, wait a minute here. Appearance of impropriety. The answer, it's like a quarterback. When a football coach says, I have 4 quarterbacks, the old axiom is, you have none. Either she worked for him in some capacity, or she did not. And if she did, it gives the appearance of impropriety. And they can't say whether she did or not. Because the answer would be yes or no. It's not these convoluted, if we had this task force, or if it does exist, or if it doesn't exist. It's a ping pong game, shell game. I get a chance. I get a chance. Fundamental fairness demands that I get a chance on behalf of Mr. Cleaves to say, Ms. Brendel, did you work for the Wayne County Prosecutor's Office in some capacity? I get a chance to ask Kim Worthy, did you know Ms. Brendel? That's my right on behalf of Mr. Cleaves. You look at this stuff, and they say, we presented evidence about a miniseries. And they say, well, that's only in production. Well, really? Well, what might be the main episode if they produce it? Right here. Right here. Opening episode. Right here. They need to do the right thing. They say, well, cash and publicity is not the reason. Well, then step aside. County Prosecutor's Office in the state of Michigan. Step aside. You look at the timing. I'm kind of cynical and not particularly trusting. So when I see people who interject themselves into a case, I see timing when the investigation was concluded. I see timing in January and February. I see charges that are brought on March 15th or 16th. I'm not unmindful that Michigan State University was one of the favorites in this year's NCAA tournament. I'm not unmindful, and I believe that they are very mindful, that Michigan State won the basketball tournament in the year 2000. I'm not unmindful that Mr. Cleaves was the player of the year that year. I'm not unmindful that the miniseries calling her the toughest lady in Detroit. That's the working title. The toughest lady in Detroit. She's not going to make her bona fides on Mr. Cleaves. Not while we're sitting here, while I'm fronting this case, fighting this case. You look at that and you say to yourself, okay, you take the case over. It's not one that you normally would take. You take it over, and you can say that somehow it's a random draw, but that's what I'm asking Ms. Worthy. How did you get in this case? How did you happen to end up here? I mean, why, with all the cases that you have in Detroit, why was your office picked? Was it a random pick? Did you call somebody? Did somebody from your office call? How did you end up with this pick? And I think that's what we need to know in order to determine whether or not there is impropriety that needs to be addressed so she can be disqualified with her office, or the appearance of impropriety. What she did, was it like little notes that were put into a jar and they're pulled, and Wayne County happened to be the one that was pulled? Or did she make a call? But the suspiciousness of the fact that she's self-described herself as this heroine of sexual abuse people. She's got a TV show in the works. She's got somebody who's well known in the state of Michigan. She times the press release at the same time as the basketball tournament. She then, with the same network that's doing her show, she then releases all this pre-trial publicity, and at about the same time she writes for a blog connected to Time Magazine, Time Warner, about her work with sexual abuse victims. You know, the idea that it's so tenuous and she doesn't know anything about it, if she doesn't know anything about it, see what gives lies to that? If she doesn't know anything about it, that means Maria Miller is writing this stuff by herself. That means that Maria Miller, well, I don't even know, and evidently she's a lawyer and the chief press spokesman for Kim Worthy, just says these things out of, you know, thin air. Maria Miller, if Kim Worthy so busy, and this is such a minuscule part of the Wayne County prosecutor's job and their collection of cases, then who's Maria Miller quoting? Who's she talking about? Because every time I see it, it's Kim L. Worthy. Every time I see that she gives line by line account of what supposedly happened, line by line a thing about Mr. Cleaves' character, line by line about you know, what he did, what he didn't do, line by line about what the lawyer did, line by line what the court did. If Kim L. Worthy is so busy and so distracted by other things, then Maria Miller should be fired immediately, because she's certainly taken literary license with Kim Worthy, because everyone I see says Maria Miller writes quoting Kim Worthy. So she's actively involved in this case. She's the one pulling the strings.
Who's the she?
Kim L. Worthy.
Okay.
But the only way, I think I've made a compelling case just based on professional misconduct. And they say, well, even if we behaved poorly, in their answer, they say, even if we have behaved poorly. I read this stuff, and I'm astounded. They said that that's not the remedy. Well, wait a minute. If we violated professional rules of misconduct, we've made it impossible for Mr. Cleaves to get a fair trial. These were not things that were just said to somebody at a water cooler. These were things that were said in mainstream media. These things went international. It wasn't just somebody whispering to somebody else in a private conversation. And they were done intentionally. She had to call her press secretary and say these things. I have to ask her why. She's got to come here. And the idea that was broached the last time we were here, that somehow she's too big to sit in that witness chair, that's absurd. Nobody is above the law. Nobody is above the law. And if she is the one who is running this investigation, in charge of this case, then she needs to explain here why she said these things, how she got this case, so that this judge can make a determination about how to proceed. And now, either Emily Brendel is not telling the truth that she worked there, or the prosecutor's office is not, doesn't know, or whatever. We need to get to the truth. We need to get to the truth. And again, it's not just about doing something wrong. It's not just about, which I think we've shown, it's not just about that, but it's about the appearance. How can you say these things about Mr. Cleaves and not feel that somebody who reads something that Mr. Cleaves is a criminal, has bad character, and feels entitled to commit sexual assault because of his position as an athlete? She doesn't know Mr. Cleaves. But she put that out there. She put that out there. Now you have to ask yourself, number one, why? Number two, you know it's wrong. Number three, how do you unring that bell? And at the very least, I'm entitled to a hearing, because the prosecutor, now I have to ask, why you care so much about Mateen Cleaves. You're a visitor. You're appointed. You're not the elected prosecutor of Genesee County. Do the right thing. Ask the court to do the right thing and disqualify her. Ask her to do the right thing, which she should have done already, and disqualify herself. Thank you, Judge.
Thank you, Mr. Manley. Ms. Lindsay?
Yes. I'll start, first of all, with factual issues about how the case got charged. What counsel is implying that the case was charged at this time to garner more publicity. What counsel does not indicate to you is during the pendency of the investigation, Mr. Manley hired a local attorney in the city of Detroit to act as a liaison with our office to keep them updated as what was going on. That local attorney was Mr. Steve Fishman. That attorney had contact with me throughout. That attorney had contact with me in January, February, and the beginning of March. Mr. Manley does not indicate to this court that I had communication with Mr. Fishman in February and indicated to him that due to the fact that I was getting slammed with additional cases and I had trials, that I would try to get to the Cleaves matter as soon as possible. He does not indicate to that to the court. I indicated specifically to Mr. Fishman that I had a trial beginning on March 14th, that I would try to get to the Cleaves matter and get some decisions going on it, because if I started my trial on March 14th, it would be another additional couple of weeks before I could get to it. The court, perhaps is not aware, but I will let the court know that I was in trial. I was the person who was assigned to issue the warrant. I was in trial. I had 2 trials, major trials scheduled in January. One of those trials got pushed back, and another had to be reassigned because my trial schedule was so heavy. Additionally, adding to that, my father had stage 4 bladder cancer. I was caring for my father. I had to have a trial adjourned in January because my father had to go into the hospital with pneumonia, renal failure, and a heart attack. So the fact that it took so long to get it issued in January, I'm sorry. I had my own trial schedule and my father's health to worry about. My trial in January ended up getting pushed to February. I was in trial for approximately all the way up to February 12th. I had another murder trial scheduled with 2 child victims and 3 surviving child victims. That trial was scheduled to start February 24th. I was letting counsel know about my trials. That trial ultimately got changed to March 14th. In addition to those trials, my other work schedule and my father's illness, the issue of the Mateen Cleaves warrant got issued when it got issued, because that's the way it happened. Not because of some NCAA tournament that we were trying to get publicity about, because quite frankly, the NCAA tournament and Mr. Cleaves was the last thing on my mind as it relates to the issue of that warrant. Mr. Cleaves' attorney indicated that we did the warrant the way we did it in an effort to get more publicity. If that was the case, we could have had him arrested instead of calling Mr. Manley and asking him to bring him in on a date specific to get the arraignment done. So that is the explanation as to why the case got issued when it issued. And the court is well aware that sometimes the work in this case has to be postponed because the probable cause conference has to be postponed in this case. And Mr. Manley knows that because I called him, is because my father had a major appointment that could not be missed and could not be rescheduled. So to stand here in court and say that the warrant was issued on specific days for specific purposes for publicity is simply not true. Now let's go to the whole publicity issue and whether the Wayne County Prosecutor's Office did something improper in the press releases. Now, the press releases in this case indicated that the conduct was alleged conduct. Mr. Manley brings up David Layton in his prosecutor's office, and Mr. Manley indicated that he has reviewed our press releases, the Wayne County Prosecutor Attorney's Office's press releases, and he says, Kim Worthy says this kind of thing all the time. Well, I reviewed the Genesee County Prosecutor's Office press releases. Their press releases are in line with what Wayne County does. But furthermore, if counsel wants to allege that a press release by Kim Worthy makes it necessary that this case disqualify us, I point this court specifically to a case Mr. Manley worked on in the Genesee County court system, which was the People versus Lawrence Woods.
Lawrence, pardon me?
People versus Lawrence Woods. In that case, his client was likewise charged with criminal sexual conduct. In that case, David Layton went on TV and gave an interview, not a press release, but gave an interview giving specific facts of the case.
I'm going to object for the same reasons I wasn't allowed to go into the murder case with a young man and a perjury charge. That's not relevant.
This is relevant as it relates to
Excuse me.
Excuse me.
Because I'm talking Layton's conduct on this case, not on any other case.
I understand that. However, she's drawing a parallel between what you allege Kim Worthy's office did, and she's trying to compare it to the Genesee County Prosecutor's Office and what he did. And quite frankly, while it might be relevant, it might be similar, this court's already aware of those kinds of things. So, you know, you can say it for the record if you want to, but I'm already aware of those things.
I'm just saying that if Mr. Layton did something and there's two wrongs, they don't make it right.
No, you're absolutely right. They don't.
But what I'm saying is, that's not what I'm actually saying is, if what Kim Worthy did in her press release is misconduct, according to the Michigan professional rules, if it's misconduct, a person who is aware of misconduct is duty bound to report it. So you can't simply say it's two wrongs to make a right. Don't make a right. In this case with Lawrence Woods, David Layton went on TV and did an interview.
I already said I was all aware of this.
But what I'm saying is, Mr. Manley was the attorney on that case. He did not come in and move to disqualify the Genesee County Prosecutor's Office from handling that case because of misconduct and publicity.
I'm going to count, excuse me just a minute, I'm sorry to interrupt. I will count this argument only as it counteracts your argument as to the press release. That's
Yes,
it. Because, you know,
that's what it's going to.
okay, that's it. I've heard enough on that.
Just for the record on that. Who's Lawrence Woods?
I don't have any idea.
That answers my question. That's
I'm aware of, okay, I'm aware of,
I have the...
excuse me, I'm aware of press conferences that are held by prosecuting attorneys, so we don't really need to go into every prosecuting attorney in every county in everything. I think the point she's trying to make is if there is unethical conduct, you should have stepped forward and done what you were supposed to do, and she's claiming you didn't do it in the Woods case. That's it. I mean, so what?
Right. Exactly. Additionally, the Woods case is instructive in terms of how it relates to this case. In the Woods case,
Is Woods a published opinion?
Woods is not even my case. Woods has a different lawyer. Woods and I separated a long time ago. And the reason I asked, Woods is just a Genesee County case. It's a sexual assault case that is being represented by somebody else.
well, now
And-
is the
And excuse me, I'm speaking. A long time ago, if he has a new lawyer, it's had a new lawyer for a long time. And the question that I asked is instructive and informative. Who's Lawrence Woods?
well, not according to the registry of actions that we have from the courts.
I haven't had Lawrence Woods in how long?
I think this part of the argument is straying into way too tenuous.
Well, but no, I understand what the court is saying, but it is related to specifically another issue in this case that deals with the supposed professional relationship between the victim and the Wayne County Prosecutor's Office. First and foremost, if you look at the cases dealing with disqualification, every single case dealt with a familial relationship.
Not true, but go ahead.
Well, the one cited by counsel
Go ahead.
in his brief. Mayhew, Doyle, Claffle, and Greer. There were cases that were argued by counsel. Those were the four primary cases argued by counsel, dealt with familial or close familial relationships. They did not deal with any type of tenuous professional relationship. And I bring that up because in the case of, let me back up just a little bit. In order to argue that Emily Brundle had a professional relationship with our office, because, and once again, let's be clear, she never said on social media she worked, let me back this up just a little bit. There is a unauthenticated LinkedIn page attributed to Ms. Brundle that indicates she worked for a Wayne County Sexual Child Abuse Task Force. It never said she worked for the Wayne County Prosecutor's Office. And if you look at the language of defendant in his brief, he said because she worked for this agency and because our office does sexual abuses, therefore there is a relationship. That's what he argued. So essentially the logic is because she worked for an agency that does the same thing we do, we have a professional relationship. That's the legal logic. Furthermore, Your Honor, his argument as it relates to Kim Worthy getting a TV show and Mateen Cleaves being the star of the show, or it was somehow related to charging Mateen Cleaves, he'd be the first episode. The court, I think, is well aware that Kim Worthy prosecuted Kwame Kilpatrick. The two have nothing to do with the other. Just because she charged, or our office charged the defendant, does not mean we charge the defendant for the purpose of her being on a TV show. That's just like me saying, I wore a red dress to court. When I was in court with that red dress, I won the case. Therefore, I won the case because I wore a red dress. That is his argument, if you follow. That is the logic of his argument. That does not follow. Your Honor, there has been nothing on this record that will give the court the right to disqualify the Wayne County Prosecutor's Office. And furthermore, there's been nothing on this record to get an evidentiary hearing. There has been a argument that because Kim Worthy was in the newspaper after he was charged, there's a link. There has been an argument that Mr. Mateen Cleaves somehow being charged is going to make her a TV star. there's not a link. The case law does not talk about disqualifying somebody for a tenuous relationship. It doesn't talk about disqualifying anybody for a speculative financial motive. And that is all counsel has alleged in this case. Thank you.
Rebuttal, Mr. Manley?
Yes, Your Honor, thank you. The law requires proof. The Michigan Rules of Professional Responsibility, Rule 3.6, trial publicity, parens A. A lawyer shall not make extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. And it goes on and talks about parent 1, the character of a party. The fact that the defendant has been charged with a crime, unless there's included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until proven guilty. If the court looks at any of the press releases that are generated by the Wayne County Prosecutor's Office in this particular case, I defy them to find. I want to see if somebody can show me the part. I will stand down and I'll apologize to everybody. If someone can show me in the Wayne County Prosecutor's Office, the largest in the state of Michigan, one of the largest in the country, where it says Mateen Cleaves is in fact been charged with a crime, but he's presumed innocent, and the charge is merely an accusation, and he's presumed innocent up until the time he's found guilty. It's not there. It's not there. So the idea that somehow I have 120 cases, felony cases. I'm not going to bore you with all the details of all my cases.
I wouldn't listen to him.
No, I understand. But the idea that I'm on this case and on that case, I mean, I had conversations with Ms. Lindsay, and I was very solicitous and sympathetic to her personal plight in terms of her family. I lost my father a year ago. So, I mean, I understand that. But the fact of the matter is, they have hundreds of lawyers. Hundreds of lawyers. So that doesn't explain anything in terms of how a case is handled professionally. Steve Fishman has nothing to do with why we're here today. Nothing to do whatsoever. Steve Fishman doesn't speak for me. I was never contacted and somehow broke my word. I never had any side deal with this court or any other court to do something untoward. Yet, not only is Kim Worthy following this case and pulling the strings, unless Maria Miller's writing on her own, they edited their press release. They violated the rules of professional responsibility first and conduct by attacking Mr. Cleaves' character, eliciting and putting out for dissemination internationally all these facts. There was no language of presumption of innocence ever included in it. But even then, in my opinion, to avoid, they wanted a perp walk. They wanted to see him chained up and walked in. They didn't get it. So they attacked this court, that somehow you and I had somehow some backdoor deal, which was completely, they attacked the tribunal. So, I mean, the idea that somehow someone's personal life or something to do with Steve Fishman negates their conduct, it doesn't. It doesn't even come close to negating their conduct. Their conduct is their conduct. They should be fleeing this case of their own accord. These are the rules, the ethical rules. She's not bigger than the rules. And the mindset, and this is the thing, this is what proves what I'm saying. The last time we were here, and I won't use all the words, when I said in response to the court that I want a hearing and I want certain witnesses, counsel stood up and said it'll be a cold day and bleep bleep before Miss Worthy's here. There is a mindset that they are above the rules. Kim Worthy's above the rules. She doesn't answer to you. She doesn't answer to me. She does what she wants. And she sends her people out to say, I'm too big. Nobody, no lawyer, especially one that's been practicing as long as Miss Lindsay, would stand up and say, it will be a cold day in bleep before Kim Worthy. She said it to the judge.
And my response was, if I order her, she will be here.
But I mean, when you have to understand the mindset that would allow somebody to make that statement. They believe they're above the rules, and they violated them. I'm calling them into question on it. They amended their press release. It doesn't explain their misconduct. People versus Doyle talks about the appearance of impropriety. The Genesee County case talks about the appearance. You don't even have to show that there's direct impropriety. The appearance of impropriety. Can it be trusted? Is there an emotional investment in this? Is there something more than just somebody coming in and doing their job at arm's length? Well, clearly in this case they are. They react immediately with press releases. They react immediately. This isn't Lawrence Wood. The reason I asked you about Lawrence Wood is, who's Lawrence Wood? No disrespect to Mr. Wood, but he's not Mateen Cleaves. So you stand up here and you use a case that nobody knows. Wouldn't he be covered? Wouldn't he be covered? We need a hearing. And, you know, I would hope that the court would see fit to just as well. It's the cleanest, easiest, most professional, ethical way. If they won't do the right thing, then I think this court needs to do the right thing and ask them. They should step away. This case has gotten to the point where everything they do now, I mean, they've issued these press releases attacking his character, saying he's entitled to commit assaults, comparing him to other people. Certain people feel because of their position. Well, who are those people? Now we've dropped Kwame Kilpatrick into it. I mean, are you kidding me? They're way too close. They're way too emotionally invested in this case. They need to go. And somebody that can actually look at this case with the clarity that their duty and their oath requires. Do justice. Prosecutors are supposed to be held to a higher standard to do the right thing. They're looking at winning at any cost, by any means necessary. And that is so wrong on so many levels, whether it's a homeless man or woman or Mr. Mateen Cleaves. And a procedural matter, they want you to say that, well, because it's written down on paper, it has to be true. If it's, you know, they say, well, it's, you know, they disparage the social media portion that she said she worked for the Wayne County Sexual Abuse Task Force. And I gave you the 14 different explanations for that they offered. But where's the affidavits? There's no affidavits. Where's the sworn testimony that, because you can't have it both ways. Either the young lady is not telling the truth that she worked on that, or Wayne County, they don't seem to know whether they even have one. And so, in terms of a task force. So, but where are procedurally? Where are the affidavits? Where's the sworn testimony? I'm deserving. I think they should be taken off this case immediately, just for public confidence. I mean, who's going to look at this case after all the things that have gone on and say that, my God, you know, aren't there some doubts? I mean, aren't there some doubts? Why would anybody take the chance that this so-called toughest woman in Detroit would put his case on TV? The idea of celebrity name dropping was just handled today. We prosecuted Kwame Kilpatrick. Okay, great. So what's the next name drop and the next big case going to be? We prosecuted Mateen Cleaves. We can't take that chance. That's a chance that, with all the other resources available in the state of Michigan to handle this case, this is the least transparent one that should be allowed. And they should be ashamed that they have not done the right thing and recused themselves. And if in fact the court does not do that, then by the minimalist standards, then I think that you know, the court's rulings, and if I subpoena Ms. Worthy, I want to know. I mean, I have questions to ask. And I, as a lawyer, as an officer of the court defending Mr. Cleaves, I certainly have that right. People versus Doyle, that case that was here. And there's very few cases, and let me add this. There's very few cases on recusing or disqualifying the prosecutor's office. You know why? Most do the right thing. Most do the right thing right out of the box. I can't think of really anybody. That's why there's not a lot of cases. They do the right thing. They're not going to do the right thing. Their actions feed right into why they should be disqualified. If they're so busy that she had this murder case and that murder case and 5 defendants and 2 survived and the little kids, I mean, that's all great, well and good. Maybe you're too busy. Maybe you're too busy, and someone else should do it. But more than that, everybody who's going to look at this case from now on is going to say, why did they want Mateen Cleaves so bad? And there's no reason to even have that out there. The court has the power. We've cited the case law. The court has the power to take care of this with the stroke of a pen. And I'd ask that the court do that and disqualify the Wayne County Prosecutor's Office. Thank you, Judge.
Ms. Lindsay, I motioned you to sit down. Would you like to add now what you wanted to say? Although I'm not going to allow you a reread presentation, but I motioned you down, and feel free to say what you wanted to say now.
Well, only that, no, the court indicated that we could make a comment after the court's ruling.
Sure.
Okay.
Mm-hmm. All right. I indicated to counsel in chambers that I had read everything and that I was prepared to rule on this, and unless something they said orally today changed my mind. And if it did, I would go back to chambers and fix my ruling. My mind has been changed somewhat, but I don't think it's to the extent that I need to go back into chambers. So this is my ruling. I'm going to tell the press right now, these are confidential judge's notes. They will not be released to the press. Beginning with Mr. Manley's motion, with paragraph number 1. And he talks about the Genesee County prosecutor recused himself. Yeah, he did. I grant you that. But to the best of my knowledge and understanding, he had nothing to do with the replacement prosecutor being picked. In fact, if you go to Michigan statute on who gets to pick a replacement prosecutor, it talks about the Supreme Court, the Court of Appeals, and the Circuit Court. Somehow I believe, and I don't know for sure, but somehow I believe that this appointment came through the Attorney General's office. How it came through, I don't know, and I'm going to address that fact in a few minutes. As to the press release, I want to talk about this press release in different paragraphs. First thing, during the arraignment, it's important to know that anyone can walk in on a felony warrant that's standing out, so an outstanding felony warrant, and surrender themselves on that warrant for arraignment at any time they please. There is a duty judge 24/7, 365 in this court. Anything, anytime can be walked in front of a judge. No arrangements were made with this court to arraign Mr. Cleaves on Thursday, March 17th, as I was the duty judge, and I was out of state. So there were no prior arrangements. They would have never been made because I would have known I was going out of state. And when the press release says all parties, I don't know for sure that they're including the court in that, but I would think it's important to have the courts okay to say we're going to bring this person in, although you don't have to. Like I said, there's a duty judge 24/7, 365. So there was no agreement with me. In addition, in part of that press release, Miss Worthy says, and I don't even think it's worth quoting, that it was clandestine. Well, I can tell you right now, NBC was in the courtroom, and the Flint Journal was in the courtroom. The public was in the courtroom. There was a public record in the courtroom. So how does this amount to a clandestine arraignment? There were words to the effect of, I don't know how Genesee County runs things. Well, I'm not a country bumpkin here, people. I graduated from law school 7th out of 115. I was working full-time and I knew I had cancer my last term. Don't insult my intelligence with comments like this. They don't work. As to the TNT movie, and I'm going to go back to that press release. As to the TNT movie, the exhibit seems to indicate that this TNT movie conviction, is what they call it in the article, is inspired by her life and is not necessarily regarding this case. At the rate this case is proceeding, which, by the way, whoever's here from the Free Press, it's not proceeding at this low rate because of the court. This movie is done. It was scheduled for the 2014-15 TV season. We're going into the 16-17 TV season. If Kim Worthy wants to make a movie about Mateen Cleaves' case, she can do it at any time. And I give you, as an example, how many movies have we had on O.J. Simpson within the last 12 months? So, the fact that she's made a movie, or perhaps is in the process of making a movie, is not persuasive to this court that they should be disqualified. In paragraph number 7, Mr. Manley, you talk about the words that were placed on the alleged victim's Facebook page, LinkedIn page. I could put on my LinkedIn page that I was a justice of the United States Supreme Court, and LinkedIn would accept it. Everybody who knows me knows it wouldn't be true, but anybody can put anything on there. And what's more important, what's on there doesn't say Wayne County Prosecutor. It could be Wayne County Social Services, it could be Wayne County Department of Human Services, it could be anything to deal with Wayne County. And it's put on there by her. I don't know if it's self-aggrandizement, I don't know. It's not substantiated. Going back just a minute to the press release. And I may run into it further in my notes, but let's talk about this press release. I have read the canons of law that you have cited, Mr. Manley. Do I believe that there might have been a violation? You bet I do. I believe that the words innocent until proven guilty should have been in there someplace. The word alleged is in there. And I agree with Miss Lindsay that the words are in there, alleged. You go out among the public and you survey 100 people, and I'll bet you those 100 common, everyday people who are not involved in law or law enforcement do not know the difference between alleged and innocent until proven guilty. But ethical violations, Mr. Manley, go to the Attorney Grievance Commission. They do not come to this court, and I believe that's the forum in which you should be. And if they find that there's an ethical violation, then this maybe should be brought back, subject to what I'm going to do here in a minute in terms of a final order. I think the press release was unfortunate, but on the other hand, I have seen the Sheriff's Department, the Genesee County Sheriff's Department, the Oakland County Prosecutor, the Oakland County Sheriff make the same kind of press releases, and they also don't put innocent until proven guilty in there. I think the whole idea of a press release, the way it was unfortunate. And if you couple that with the fact that I tried to seal the records in this case, and I was overruled, and an order of superintending control was entered that I had to vacate my order of sealing, has completely disillusioned me to the point where I believe, and it disappoints my heart, but I believe sensationalism now trumps justice. I really do. There was a comment made by Ms. Lindsay, and I'm addressing another paragraph, Mr. Manley, in your motion. At the PCC, and the two of you know what I'm talking about, I'm not going to bring it up again, that was unfortunate and, in my opinion, unwarranted. It should have never been made. It was not timely to make it. There should have been more substantiation, more accountability prior to it being made, and I believe that I have made my opinion very clear on that point. Now, let's look at the case law. Let's look at People versus Mayhew. The prosecution argued that the victim had lost both a husband and a father, and that the prosecutor tried to emblazon the jury's minds of the victim by making comments and displaying pictures. The Mayhew court said, there is no miscarriage of justice if it can be cured by a curative instruction at trial. This case involved a prosecutor who may or may not have had an emotional tie with the victim, who had gone to school, I believe, with his son. They were best friends with the son, but in fact at the time this particular prosecutor got the case, I believe the victim had gone to another school and they were no longer best friends. I didn't write that down, but I think that's how the case went. They also said comments in the context of an opening and closing arguments were not blatant appeals to the jury's sympathy and were not so inflammatory that the defendant was prejudiced. The Mayhew court's trying to tell me that if there's been any comments made thus far that were improper, they can be cured in front of a jury. Plus that, you want to remember, I am not a jury. I am merely a district court judge. All I do is decide whether or not there's enough evidence to bind Mr. Cleaves over for trial. So nobody's antics, displaying of pictures, yelling and screaming at me, trying to belittle me in the press is going to make any impact on me, because I have one job to do, and that's it. Decide whether or not there's probable cause. In the Mayhew case, the defendant argued while the officer should have been disqualified because the victim was the brother of the head of the family division, the court said, the determination of the existence of a conflict sufficient to warrant disqualification is a question of fact to be reviewed for clear error. At Head Note 13, they say, the prosecutor has a personal, financial, emotional, litigation, or personal relationship with the accused. Is there a personal relationship between Miss Worthy and Mr. Cleaves? While I don't know Mr. Cleaves or Miss Worthy, I'm going to believe there is not a personal relationship. Is there a financial or emotional motive? I'm going to get to that. Litigation or a personal relationship? I don't believe so. I think just this case is the only connection that they have. After the determination of a conflict, you must then look to the entire office as to whether to disqualify. If the prosecuting attorney concerned in the conflict, and this is critical, if the prosecuting attorney concerned in the conflict has supervisory authority or policy-making authority, then recusal of the entire office is likely to be necessary. Keep that quote in mind. The victim's brother was not involved in the case and not involved in any manner with the attorneys involved in the case. Then I want to talk to People v. and I can't pronounce it, P-F-A-F-F-L-E. Here, the defendant was charged with 2 counts of inducing a minor to commit a felony and 4th-degree CSC. The defense claimed that the prosecutor had a personal connection with the victim of the attempted kidnap and the attempted rape and murder and knew see, I got the 2 cases confused. This is the one where the kids were best friends. Was one of the victim's best friends. The defense attorney knew about the connection early in this case, but did nothing about it until sentencing. And the defendant didn't know anything about it till sentencing. Prosecutor claims he only met the victim at the lineup. The boys were no longer friends. Okay, here's what the court said. The court commented on the small number of times the prosecutor and the victim's family had met. And I quote, "Such a connection in a small community like Marquette is commonplace. The judge saw no indication of any personal involvement." Let me comment that the reverse can be true. Detroit is a very large community. And just because it's a large community does not mean that Miss Worthy has any kind of emotional or personal interest in this case. So while the judge in the Fackle case, is that how you pronounce it, said that such a connection in a small community like Marquette was commonplace, the same can be true in the reverse. Detroit's a large community. Not only that, geographically they're separated. Wayne County and Genesee County. So I don't find any convincing on that point. The law is clear, and again I'm quoting the court. The law is clear that a prosecutor's fundamental obligation is to seek justice, not merely to convict. Oh, gee, then you're going to put out a press statement like you did? Not only maligning the defendant, who has not been convicted yet and is presumed innocent, but you're also going to malign the court? Excuse me. The prosecutor's duty, and I quote, his fundamental obligation is to seek justice and not merely to convict. The legislature has allowed for the appointment of special prosecutors when a conflict exists and that a conflict can be closed or otherwise has a keen judgment. Any resultant prosecutorial misconduct that denied the defendant a fair trial and it's important, Mr. Manley, listen, that denied a fair trial or led to a conviction would surely entitle the defendant to a new trial. That quote speaks specifically to a fair trial. It does not speak to a preliminary exam. Now let's go to the People v. Doyle. And for reasons that are abundantly clear to some of us who have been around, I have changed the words. Here, this is a Genesee County case. And here, the defendant sought to disqualify the whole Genesee County Prosecutor's Office. There were consolidated cases. One defendant had been charged with delivery of cocaine, and in a separate case, 3 others had been charged with assault with intent to commit great bodily harm. The defendant, Doyle, married into a high-placed staffer's sister-in-law. The defense thought that there was a plea agreement, but there wasn't. The defendant moved for a remand. 9 counts were remanded. 1 case wasn't. It was denied a remand, and hearings were conducted on whether or not there was a plea agreement. Not on whether there should be a disqualification, but on a plea agreement. The AWI-GBH cases were waived to circuit court for the special purpose of determining whether the prosecuting attorney and the staff was disqualified for a conflict of interest. And remember, in the prior case, I believe it was Mayhew, they said if there's any kind of supervisory authority and or policy-making decision, then the whole office goes. The defense attorney agreed that they had a problem with whether there was a plea agreement or not. The prosecutor never said we had an agreement, but rather said, you know, this is the defense attorney talking. He said, the prosecutor never told me we had an agreement, but I had the impression that we had a conditional agreement because he believed that there was an agreement if it was approved by the police officer in charge. And relying on that belief, believe it or not, he allowed the defendant to be interviewed by the police, which, without a written plea agreement, I don't know why you'd do that, but he did. The police suggested a waiver of the prelim and to put the plea agreement on the record. The defense attorney agreed, and it was done. Then the prosecutor, a former Genesee County prosecutor, called and said, no deal. We don't have a deal. So they had a hearing. The defense counsel testified that he talked with the staffer, whom Doyle was now related to by marriage, and the staffer said he could not make any decisions and was not involved. The defendant's attorney said he understood the staffer was not involved, but the staffer was speaking for the prosecutor, and all of his discussions had been with the staffer. He'd never spoke to the prosecutor. The staffer testified he did have discussions, but denied he indicated that they had a plea agreement subject to the police approval. The staffer testified he was speaking for the prosecutor and had related conversations. The staffer testified, that's in. Don't forget the staffer testified. The circuit court disqualified the office, saying that there was an appearance of impropriety. All right. You argued to me, Mr. Manley, that an appearance of impropriety is terribly important. I absolutely agree with you. Every day as a judge, I must live my life with no appearance of impropriety. And I'm going to tell you right now, one of the hardest things to do is keep my mouth shut about the presidential election. But I have to, because I cannot show an appearance of impropriety. And the circuit court disqualified the Genesee County Prosecutor's Office. But we have totally different things going on here. And I believe Doyle is the most important case because Doyle is based on Greer, which is a California case that the Michigan Supreme Court adopted. The Michigan statute cites 3 courts that can disqualify the prosecutor. And those courts, and I will refer you, Mr. Manley, to the statute. It's MCL 49.160. And I will quote it for you. If the prosecuting attorney of a county is disqualified by a reason of conflict of interest or otherwise is unable to attend to the duties of the office, the Supreme Court, the Court of Appeals, or the Circuit Court for that county, upon a finding to the effect by that court, may appoint attorney-at-law to act as special prosecuting attorney to perform the duties of the prosecuting attorney in the respective court in any manner in which the prosecuting attorney is disqualified or until such time as the prosecuting attorney is able to serve. You will note by statute the district court is not mentioned. If there is a financial, emotional, kinship, friendship, or animosity, the rules of ethics require, under Canon 9, that they should avoid even the appearance of impropriety. The bell has been rung here. You cannot unring a bell. The eggs have been scrambled. You can't unscramble them. I admonish counsel, and even the counsel who is not here, that no matter which way I decide, I will be watching. And if I require further, you'll be told so. The prosecutor must prosecute vigorously, and I think I've mentioned to Miss Lindsay that she has a vigorous style, but also impartiality. The duty is to obtain justice, not merely to convict. I can't repeat that enough. In the second part of the Doyle case, I don't find it very convincing because there was an order signed by a judge to disqualify the prosecutor's office, and the court in Doyle vacated that order. Now, this is very interesting because the statute says Supreme Court, Court of Appeals, Circuit Court. The Doyle court vacated that order and said that this judge did not have jurisdiction because the case was in district court. But yet they don't say district court has the power. Interesting. This case relied on the People v. Greer, which is a California case. It does not apply in Michigan, and let me tell you, I'm going into that. Although, except to the extent that it was cited by the Supreme Court in the Doyle case, it then becomes precedential to me. Now I want to address the people's response. I'm not interested in other states' decisions. I am a district court judge for the state of Michigan, and I look first to my own appeal hierarchy. It's a complete waste of my time to study what other states are doing, especially where Michigan has codified the process for appointing an attorney when then one is disqualified. I agree on the reference on the LinkedIn is too tenuous to even have the appearance of impropriety, although I think I've changed my mind on that. As I said earlier, I could list that I was a U.S. Supreme Court Justice. Find the use of the word alleged to insult my intelligence. It is not the same as saying innocent until proven guilty. But again, as I said before, this is a matter for the Attorney Grievance Commission, and I find no case law citing similar ethical violations that resulted in a disqualification of the prosecutor's office. As a PS to this, I was not provided by either side ethical opinions to bolster the appearance of impropriety argument, and it may be because they don't exist. I don't know. Now, I can't read my last paragraph because I have changed my mind. At this point in time, I am not going to disqualify the Wayne County Prosecutor's Office based on the reasons that I have outlined. However, I'm holding that. I said, remember, I said at this point, I want affidavits. I want an affidavit from the alleged victim, and I want an affidavit from Miss Worthy. And this is a court order. I want an affidavit from the alleged victim as to who, what, where, when, and why the Wayne County Child Sex Abuse Task Force. Please look to the words of Doyle. I want to know if there was any supervisory control by Miss Worthy or any member of her staff, or any policy making as to Miss Worthy and her staff. I want an affidavit from Miss Worthy as to the same who, what, where, when, and why. I would like the word, I'm not ordering this, I'm saying I would like the word to go back. That I am not a country bumpkin, and I do not expect to be treated as such. So that's my order right now. I cannot say I'm not going to disqualify. I'm going to say I need further information. I am not going to, at this point, hold an evidentiary hearing, although it may become necessary. I don't know. I want to see the affidavits first. You have 10 days to get those affidavits. I am going to take about a 5-minute break, and then we'll go on to the second motion. Yes, Ms.
You
Lindsay.
indicated that we would be allowed to say some things after your ruling.
If I'm going to take a 5-minute break, I have to, and then you can say something if you want about my opinion.
Okay, yes.
All right? But I am going to take a 5-minute break. Probably might, to tell you the truth, lead into 7 minutes.
All right. You may be seated.